All right, be seated. Good morning, everyone. All right, it looks like we are live streaming and we are recording. So I will convene the hearing on the unanimous settlement agreement in the matter of the application of Atmos Energy Corporation for adjustments of its natural gas rates in the state of Kansas. If you're participating online, please bear with us if you experience any technical glitches. We'll go off the record to address any of those if anything comes up. So with that, we will begin with our entries of appearances, and we will start with Atmos Energy.
Good morning, Commissioners. James G. Flaherty, Ottawa, Kansas, appearing on behalf of the applicant, Atmos Energy Corporation.
All right. Good morning. For Curb.
Thank you. Good morning, Commissioners. Joseph Astrap, Consumer Counsel, and Attorney John Racy on behalf of the Citizens Utility Ratepayer Board, or CURB.
All right. Good morning. And finally, for KCC staff.
Good morning. Hassan Latif on behalf of myself, Carly Massentine, and Patrick Hurley representing Commission staff and the public generally.
All right. Thank you. Good morning, Mr. Latif. Next, we will move to notice of this hearing. Does staff have a recommendation regarding notice?
We do, Chair. KSA 77518 requires the presiding officer to give reasonable notice, written notice within 10 days prior to the hearing to all parties. On January 9th, all parties of this docket filed a joint motion to approve unanimous settlement agreement, wherein all parties requested the Commission convert the evidentiary hearing scheduled in this docket to a one-day hearing on this date. And on January 12th, the Office of General Counsel for the Commission notified the parties in writing that the Commission planned to grant the motion and set the hearing for January 28th. On January 22nd, the Commission issued its order wherein it stated that the evidentiary hearing previously scheduled in this docket would be converted to a one-day settlement hearing that would be held at 10 a.m. on Wednesday, January 28th in the first floor hearing room at the Commission's office in Topeka. The order was served on all parties in the docket at that time. Accordingly, staff has examined the notice and asked that the Commission find that notice in this matter is proper and that the Commission has the authority to convene this hearing at this time and place.
All right. Thank you, Mr. Latif. Any objections to a finding that notice is proper? Hearing none, I will find that notice is proper and the Commission has jurisdiction over this proceeding at this time and place. We will now move to just preliminary matters. I understand we have at least one, which is that the parties have asked to admit or they're planning to move to admit all pre-filed testimony into the record. Mr. Flaherty, is it your intention to make that motion?
Yes, it is. As part of the unanimous settlement agreement, the parties agreed that all pre-filed testimony and exhibits would be referred into the record and waiver of cross-examination. So at this time, I would move that all the pre-filed testimony and exhibits, including the testimony in support of the settlement for today's hearing, be referred into the record.
All right. Any objections? Hearing none, the motion is approved. All the reference testimony and exhibits will be admitted into the record. Are there any other preliminary matters the parties wish to take up before we move on to the rest of the proceeding? Seeing none, I will move to a brief description of the procedure for this hearing. First, I understand that Atmos will be making a brief opening statement of approximately 10 minutes. And then we expect them to be followed by CURB and Commission staff who will have short opening statements as well, 3 to 5 minutes for each of them. After opening statements, we'll then follow the order of witnesses that was agreed to in the pre-hearing conference. And I understand also that at the pre-hearing conference, the parties indicated that they do not anticipate filing post-hearing briefs. So with that, that is the procedure we'll follow today, and we will move directly into opening statements, beginning with Atmos and Mr. Flaherty.
Thank you. And you should have copies of the PowerPoint presentation that I plan to use in making this opening statement. There we go. So the purpose of this hearing is to submit to the Commission the unanimous settlement agreement for approval. This hearing will allow you to ask questions of the various parties with respect to the terms and conditions contained in the settlement. What I would intend to do during this opening statement is to walk you through the terms and conditions of the settlement at a higher level, and then please direct any questions you have to the witnesses that are testifying in support of the schedule. So this slide just provides you an overview of the areas in which Atmos Energy provides service to in the United States. They serve over 3 million natural gas customers in 8 states. And in addition to Kansas, they provide service to Colorado, Texas, Mississippi, Louisiana, Tennessee, Kentucky, and Virginia. This next slide shows you the areas in Kansas in which Atmos Energy provides natural gas service. Atmos currently serves about 140,000 customers in about 110 communities spread out across the state of Kansas. Since its last rate case, and in conjunction with both its efforts and the Commission's efforts with respect to the pipeline replacement program that this Commission approved back now, I guess it started in 2019. As part of that, since its last rate case, Atmos Energy has spent about $137 million in capital improvements. And as for each gas utility, Atmos Energy files an annual replacement plan with the Commission and identifies those areas where it uses its capital investment to strive to meet the conditions that were set forth by the Commission in that 2019 replacement program. So in this hearing, the settlement was filed by all the parties, staff, CURB, Wood River, and Atmos Energy on January 9th. It was agreed to by all the parties. The settlement takes care of all outstanding disputed issues that were raised in the pre-filed testimony. And staff, CURB, and Atmos Energy are filing or have filed and will present witnesses at today's hearing to support the settlement, to answer any questions the Commission might have with regards to those terms and conditions. On behalf of Atmos Energy, Kathleen O'Connor, who's Vice President of Rates and Regulatory Affairs for the Colorado and Kansas Division, will be testifying, and she will be able to answer any questions you might have. She actively participated in all of the settlement discussions and is familiar with the terms and conditions contained in the settlement. We also have on the line virtually Mr. Greg Waller. He's the Director of Rates and Regulatory Affairs for Atmos Energy. He was the chief accountant in this case, and in case the Commission has specific questions as it relates to accounting issues, he would be available to answer those questions. He originally planned to be here in person, but because of the weather, he was unable to get out of Dallas to make the hearing this morning. So again, as I indicated, what I'd like to do in this opening statement is just walk the Commission through the terms of the settlement. As you can see, there's 13 primary terms that are addressed in the settlement. The settlement deals with the stipulated revenue requirement deficiency that was agreed to by the Commission. That includes the rebasing of the GSRS revenues that are currently recovered through the GSRS surcharge. It identifies a carrying charge that will be applied for purposes of calculating the GSRS, the SIP, and any KSA 66 1239 filings that are made in between the time the Commission makes its decision in this case and its decision in the next general rate case filed by Atmos Energy. The settlement deals with the rebasing of the GSRS revenues It also discusses the cost of capital issues, including the capital structure, the cost of debt, and cost of equity. It addresses Atmos Energy's request for an abbreviated rate case. Its request for a tax rider tariff. The parties were able to reach agreement on the new rates. And there's a provision with respect to the class cost of service studies and rate design issues that were raised by the parties. The settlement agreement also includes a weather normalization adjustment agreement. It addresses the EFM tariff revisions that were proposed by Atmos Energy. One issue that is probably new to the commission is that the settlement addresses the accounting treatment for cloud accounting. And I will discuss that issue in a little more detail when we go through each of the issues. Atmos Energy, as part of its rate case, filed new depreciation rates based upon a new depreciation study. And the parties were able to come to agreement on those new depreciation rates. And then finally, the parties agreed to request that the commission set an effective date for the new rates. So with respect to the issue one, which is the revenue requirement increase and the rebasing of the GSRS revenues, the overall annual revenue increase that was agreed to by the parties is $17.69 million. Out of that, all the parties agreed that the GSR revenues of $5.699 million would be basically rebased, and that the GSRS charge would be reset at zero. And if taking into account the GSRS revenues, the net annual revenue increase that was agreed to by the parties is $12 million. This next slide basically shows a comparison of the stipulated increase that I just discussed with the parties' recommendations. And since all the parties agreed to the GSRS revenues, which is in that middle column, I did direct your attention to the last column. So in this case, Atmos Energy, in its rebuttal testimony, was requesting a $19.93 million revenue increase. Staff's proposal was at $10.24 million, and CURB's recommendation in its cross-answering testimony was $11.35 million. And so you can see how the various recommendations relate to the $12 million that was stipulated by all parties. So the stipulated revenue requirement, as you can see, falls within the low end and the high end of the various recommendations. Would point out that when you consider all of the evidence that was presented, it has been admitted into the record today, that the revenue requirement is supported by substantial competent evidence, which is one of the factors the commission needs to consider. I would indicate for the record that staff and CURB conducted a 4.5-month audit on Atmos Energy's case that it filed back in July. If you count all the subparts of all the data requests that staff and CURB submitted to the company for responses, it added up to just under 420 data requests. And so there was an extensive analysis done of the case and related or resulted in the filing of the pre-filed testimony that's been admitted into the record. Issue two addresses the carrying charge that's going to be applied to GSRS, SIP, and 66-1,239 filings in between when the commission issues the order in this case and when it issues the order in the next general rate case. The parties agreed that for purposes of calculating those filings, that they would use a carrying charge of 8.97% gross of tax number. Mr. Onrein explains in his testimony in support of the settlement that 8.97% is very close, if not identical, to the recommendation that the staff made in this case. Because it's a gross of tax number, should tax rates change between now and the next Atmos Energy rate case, the carrying charge will be adjusted to reflect that. And the parties also agreed, I mean, the commission's familiar with the GSRS and the SIP filings. This KSA 66-1-239 filing is probably something new. To my knowledge, there hasn't been a filing under that statute that was just passed recently. But it does require that if those filings are made, that a carrying charge be used. And so the parties agreed to use that same 8.97% gross of tax. With respect to issue 3, the rebasing of the GSRS revenues, Atmos Energy, if you looked at the original filing, had suggested that it maintain its GSRS surcharge and not to rebase it. The thinking on that was that provided transparency to the customers since it's a separate charge. However, after discussions with staff and CURB and taking a look at one interpretation of the GSRS statute, the parties were able to reach agreement that we would go ahead in this rate case and in future rate cases to rebase all GSRS revenues so that that would be done in each subsequent rate case. Issue number 4 basically deals with cost of capital issues, basically the capital structure, the cost of debt, cost of equity. Parties weren't able to come to an agreement on any of those 3 issues, but they were, like I said, able to come to agreement on a carrying charge to be used in between rate cases. And would note that there was no specific agreement on the return on equity. But again, if you take a look at Mr. Unrein's testimony in support of the settlement, he provides you some idea as to where somebody looking at all the evidence and looking at the settlement terms could come to an understanding as to where that return on equity that was used to provide the carrying charge amount came from. Issue number 5, Atmos Energy in its rate case had asked for the use of an abbreviated rate case. The purpose for that request was to capture CWIP, construction work in progress projects that were not completed at the time the commission staff completed its audit. And the way the statute reads, those projects would have been eligible for recovery if approved by the commission. And Atmos Energy believed that using an abbreviated rate case would allow the ability to capture the capital investment in those projects. But the parties, as part of the settlement, Atmos Energy agreed to withdraw its request for an abbreviated rate case. Issue number 6 deals with various accounting matters. If the commission, I'm sure the commission's familiar with other settlements in rate cases. In most of those settlements, there are certain accounting matters where the parties and the commission have to agree on what the specific amount that's included in base rates relates to, so that they then can use that amount to determine, again, filings in between rate cases. The first issue relates to ad valorem tax expense. The amount that the parties agreed to that's included in base rates is at the bottom of this slide, $9,371,787. So that will be used in future ad valorem tax surcharge filings. The one thing that was left out of the agreement, settlement agreement, but the parties agreed that we could submit on the record this morning, is that in looking at the $9,371,787 number, that should have been broken out into a gross amount and a capitalized to CWIP amount. And so for the record, the gross assessment amount is $9,511,765. And the capitalized to CWIP amount is $139,978. And like I said, the parties agreed that we would include that for the record in this hearing. Some of the other accounting matters dealt with the amortization periods for recovery of actual rate case expense and pension and OPEB deferrals. The amortization period for both of those is 3 years. Also the amounts that are that are going to be amortized are set forth on this slide and included in the agreement. And then finally, for purposes of calculating the pension tracker going forward, the amounts that are in base rates were agreed to by the parties and are set forth at the bottom of that slide and included in the settlement agreement. Issue number 7 related to the tax rider tariff, and this again relates to, I think, a relatively new statute that as far as I know, no filings have been made under that statute. But in what Atmos Energy had originally proposed was to include in the rate case request a tax rider tariff. Based upon staff's testimony and the testimony of Mr. Unrein, he suggested that instead of using a tax rider tariff, that Atmos Energy could use this KSA 66(1)(239) statute to basically do the same thing, capture any significant changes in taxes. And so the parties in the settlement agreement agreed that Atmos Energy would be allowed to use the provisions in this statute to file an application if the qualifications are met under the statute to reflect the tax changes that they expect that are going to occur for fiscal year 2027. Under that procedure, what happens is that Atmos Energy would file an application with the commission setting forth the amounts, making sure that the statute has a certain threshold level. And if that threshold level's met, then the application can be filed. It then allows the commission to set the amount that is in deferred, and it could either be a recovery or a refund amount. And then that amount then using the carrying charge that's agreed to by the parties, in this case at 8.97% gross of tax amount, will be applied to that. And then the commission would approve the recovery of that in Atmos Energy's next general rate case. Issue number 8, the class cost of service and rate design. As in most rate cases, the parties really weren't able to come to a specific agreement on what class cost of service study should be used or the rate design. And so a settlement was reached on both of those things, or both of those issues. The parties agreed that the rate increase should be allocated among the classes, and that is set forth in Appendix B to the agreement. And the new rates are also set forth in Appendix B to be approved by the commission. One highlight is the monthly residential class customer charge is to be set at $23. This next slide basically compares the current Atmos Energy rates with the rates that are set forth in Appendix B to the settlement. As you can see for the first line there, the residential sales customers, the facility charge is going to be increased from $19.75 per month to $23 per month. That $23 is comparable to the current facility charge plus the GSRS charge, which is about $2.30. And so the customer, which is going to be reset at zero. So the customers will, combined, the new facilities charge is going to be about the same amount as what they were paying under the facilities charge and the GSRS charge. This slide also shows the commodity rate changes. The result of these new rate increases means that a residential customer that uses about 67 CCF a month will see an increase in its bill of about $5.69. Issue 9, the parties were able to reach an agreement on the weather normalization adjustment numbers and the customer annualization numbers. The numbers that relating to the W&A factor that is set each year in between rate cases is set forth in Appendix C to the agreement. Issue number 10 related to EFM tariff revisions that were proposed by Atmos Energy. Basically, the request was that that customers would have to pay for any new EFM equipment that was required. As a result of settlement discussions and staff's recommendation by Witness Heffley, parties were able to come to agreement on that specific language. And so staff wanted clarifications to the language that EFM equipment would have to be paid for if it became inoperable or if it was no longer technically able to provide the service that was necessary. Issue number 11, and I did want to spend some time on this issue. This relates to the accounting treatment for cloud computing. And unfortunately, the parties were not able to reach agreement on this issue, except for the agreement to be able to raise this issue in Atmos Energy's next general rate case. If you're looking for a good description of the issues relating to this issue on both sides, both the company's side and the positions taken by staff and CURB, I direct your attention to Mr. Unrein's direct testimony at pages 26 through 33. He does a good job explaining both sides of the issue and basically the requests made by Atmos Energy. I think the parties were, at least from our standpoint, the parties, during settlement discussions felt like this issue needed further review. I would point out that Atmos Energy has received this type of accounting treatment in a few of its other jurisdictions. That was one of the main reasons why we were seeking approval of this issue in this case, to be consistent with those other jurisdictions. But again, the parties thought that they need to have further review of this issue. This issue is probably going to come up in other rate cases that you might see between now and when Atmos Energy files its next rate case. But like I said, I'd be happy to go into more detail, but I think Mr. Unrein does a really good job explaining both sides of that issue. Issue 12 on depreciation rates. Atmos Energy's assets are basically divided up into three areas. The assets that relate to Kansas directly, the assets that relate to the Colorado-Kansas division that provides services to Kansas, and then the shared services that Atmos Energy provides to Kansas. The parties were able to reach agreement on each of those areas of assets, and the new depreciation rates are set forth in Appendix A to the agreement. Finally, issue 13, the parties agreed to request that the new rates be approved by March 1st of 2026, mainly because we were able to reach a unanimous settlement agreement, eliminate litigation, and the additional time and expense that's built in the schedule at the end of the schedule to allow the commission adequate time to review if the case was litigated and the commission had to look into each specific issue. Because we were able to avoid that, the parties all agreed that they would request that the commission consider having an effective date of the new rates on or before March 1st. This last slide basically sets forth the three factors that this commission is well aware of when reviewing a unanimous settlement agreement. There has to be substantial competent evidence. The settlement has to result in just and reasonable rates, and settlement has to be in the public interest. Each of the witnesses that are going to appear today are here to answer your questions that you have with respect to those three factors, and I'll let them address any issues you have with respect to those, as set forth in the joint motion that was filed by the parties that went into some detail as to how each of these three factors have met. I'd let you take a look at that as well. And with that, thank you for your time, and we'll be happy to answer any questions that you have.
All right. Thank you, Mr. Flaherty. Thank you, Atmos. We will now move to Curb. If you have a brief opening statement, Mr. Astrab.
Thank you, Mr. Chair, members of the commission. Good morning, and thank you for the opportunity to present evidence in support of the unanimous settlement agreement in this docket. As the agency tasked with representing the interest of residential and small commercial ratepayers, Curb evaluated Atmos' application with a view towards affordability and reliability. Curb understands the growing pressure that households are facing with rising costs, including ones for utility services. The net $12 million revenue increase falls within the range of proposals put forward by each party and shows a balance of competing interests. The agreement provides for a reduction of over 30% of the company's initial request, which dampens how much bills are impacted by this case. From Curb's view, the provisions establish terms and conditions in line or close to Curb's and staff's filed positions. This illustrates the level of consideration that was given for each of these interests in resolving disputes and setting new rates. While bill increases are rarely desirable, we believe that the settlement represents a reasonable resolution of the company's request to recover expenditures and operating costs based on maintenance of the system and reflective of economic conditions today. Curb witness Audrey Benham is here to answer questions regarding Curb's involvement in the docket and our perspective on the outcome of this application. She will be able to answer questions regarding Curb's analysis of the application and the issues that impact ratepayers the most. The revenue increase reflects a reasonable pace of recovery for investments made to improve the quality and reliability of utility services while moderating the impact on the fixed and volumetric components of bills. Withdrawal of the request for the abbreviated rate case and capitalization of cloud computing costs as part of this docket also help mitigate the need for further rate increases and payments related to this filing. Through the presentation of today's evidence, we will join in the other signatories to ask the Commission to approve the unanimous settlement agreement in this docket as presented. Thank you for the opportunity to speak today.
Thank you, Mr. Astrab. And finally, KCC staff, Mr. Lateef.
Thank you, Chair and Commissioners. Staff supports the statements made by Atmos and Curb in their opening statements and wishes to expand on why staff supports the settlement agreement before the Commission. Staff's witness, Chad Unrein, will testify that the unanimous settlement agreement meets the standards used to review unanimous settlement agreements in that it is supported by substantial competent evidence, results in just and reasonable rates, and is in the public interest. Staff's analysis includes the following highlights for consideration. First, that the agreement is supported by substantial competent evidence in the record. Although the testimony filed by the parties in this case has been exhaustive, there are a few numbers outlined in the settlement agreement which form the basis for the agreement made by the parties as part of this settlement. In its direct and rebuttal testimony, Atmos requested amounts of 19.93 and 19.06 million. And in its review of the data provided by Atmos, staff originally proposed a much lower net revenue requirement increase of 10.25 million. The parties reached a settlement proposal of 12 million instead, acknowledging that no specific calculation results in the agreed 12 million and that the parties may have different understandings of the concessions involved. From staff's perspective, there are several changes that explain the difference between the filed net revenue requirement increase of 10.25 million and the settlement agreement increase of 12 million. We relied on modifications to 5 of staff's adjustments that primarily account for staff's range of movement in its net revenue requirement position. The modifications include 2 corrections related to the accumulated deferred income taxes and regulatory liabilities associated with excess deferred income tax adjustments that resulted in revisions to staff's revenue requirement. In addition, staff recognized 3 additional modifications to its adjustments to reflect settlement positions, including staff's proposed depreciation expense related to the modification of corporate depreciation rates, adjustments to its operations and maintenance, and the inclusion of construction work in progress projects that Atmos placed into service through November 30th, 2025. Staff also considered litigation risk and costs, which is set out in more detail in the filed written testimony. As a result of the settlement, the average residential customer will experience an increase of approximately $5.69 per month based on the average annual residential usage of 67.3 CCF per month. By percentage, these residential customers would receive a net increase of approximately 6.81% on their total monthly bill. Meeting the second standard, the agreement results in just and reasonable rates. The unanimous settlement agreement results in rates that fall within the zone of reasonableness as determined by Kansas courts. The zone of reasonableness balances the interest between stakeholders that have competing priorities, including investors versus ratepayers and present ratepayers versus future ratepayers, resulting in rates that are in the public interest. This opinion is supported in part by the fact that the revenue requirement of 12 million agreed to by the settlement is closer to staff's filed position of 10.25 million than the Atmos's requested increase of 19.07 million. Staff's direct testimony was filed with the intention of balancing all the interests represented in this case, and the agreed upon total revenue increase is a substantial adjustment in rates from the filed position of the company. Yet, the revenue requirement increase in the settlement strikes the proper balance between the company's desire to earn sufficient revenues and cash flows to meet its financial obligations and the need to keep rates as low as possible for the customers while providing reliable natural gas distribution service. In short, the level of cost recovery afforded under this settlement reflects Atmos's costs of providing reasonably efficient and sufficient service. And finally, the settlement agreement is in the public interest. There were multiple interests represented by the parties involved in this negotiation. Atmos represented the interests of its management and shareholders. CURB represented the interests of residential and small commercial ratepayers, and Wood River represented the interests of transportation customers. Staff balanced the interests of the parties, which while representing the interests of the public generally. The fact that the parties in this case, with diverse and often competing interests, have found common ground for resolving their respective issues strongly supports staff's contention that the agreement is in this case will result in just and reasonable rates that are in the public interest. Generally, the public interest is served when ratepayers are protected from unnecessarily high or discriminatory prices and unreliable service. Therefore, it is staff's opinion that the agreement meets the public interest because it reduces the amount of Atmos's requested revenue increase closer to staff's filed position. It provides Atmos with sufficient revenues and cash flows to meet its financial obligations and provide reliable service. It allows Atmos to continue to utilize the GSRS mechanism as authorized by statute to continue replacing its aging infrastructure in the state. In settlement negotiations, each of the parties represented their respective interests by putting time, thought, and professional analysis into delivering a settlement position it found reasonable. And the stipulated revenue requirement increase was based on the record, and it's a reasonable compromise among the parties based on each party's own analysis and of a reasonable outcome. And if this agreement is approved, the parties would avoid the costly and time-consuming process of fully litigating this matter. It is in the public interest to avoid such costs if possible, and this agreement accomplishes that result. Therefore, the settlement agreement that is the basis for this hearing represents a reasonable resolution of the issues in the docket, results in just and reasonable rates, is in the public interest, and is supported by substantial competent evidence in the record. Therefore, staff recommends the commission approve the settlement agreement, and thanks you for the time and consideration.
All right, thank you, Mr. Lateef. All right, we have concluded opening statements and we will now turn to the examination of witnesses. Atmos, you may call your witness.
Yes, Atmos Energy would call Kathleen O'Connor.
Good morning, Ms. O'Connor. And before you sit down, if you would please raise your right hand for me. We don't have a court reporter, so I'm going to swear you in. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth? All right, go ahead.
Please state your name and business address for the record.
Sure. My name is Kathleen O'Connor. My business address is 25090 West 110th Terrace in Olathe, Kansas, 66061.
Who is your employer?
Employer is Atmos Energy.
What is your position with Atmos Energy?
My position is Vice President of Rates and Regulatory.
And in that capacity, did you file testimony in support of the settlement?
Yes, I did.
Okay. Your Honor, I believe all the testimony has already been referred into the record. So at this point, I'd tender Ms. O'Connor for commissioner questions.
Thank you. All right. Yeah, since everybody's waved across, we will just move directly to commissioner questions. I will begin with Commissioner Keen if you have any questions.
Good morning, Mr. Connors.
Good morning.
If you could draw that microphone maybe a little closer to.
Absolutely.
So
You hear me okay here?
that's better. Thank you.
Perfect.
I try to put my glasses on so I can hear better. Some understand that. Let me ask you this. Kind of a holistic and general question to start with. Why do you believe that the settlement agreement is in the best interest of the company?
Sure. I appreciate the question. I feel like the settlement that we have in front of the commission today provides a really good balance that meets the overall safety and reliability and affordable for the long term of our customers. We had some really great discussions within the settlement conference, and I feel like the overall impact and the continued reliable service that we've been able to provide to our customers, and happy to report, given the weekend extreme winter event that we went through just recently, we had no service interruptions and our system performed as we had planned. And I think that shows value in the ongoing investment that we are making in our system, and that's just demonstrated by the reliability that we were able to provide this weekend when our customers expected it and needed it the most.
Okay. And congratulations on how well you did perform during Fern.
Thank you.
I think that's really quite commendable. Reliability from the gas sector is really critical to all of the customers that you have. Correct me if I'm wrong, but is not a fair amount of certainly the eastern portion of your service area, was that not the old Union Gas area?
I believe that's correct. Yes. Mm-hmm.
Okay. And to what extent are there still serious steel replacement issues here and other safety related issues that are kind of built into the cake of what you see as priorities?
Yeah, absolutely. So, we have continued to file for pipe replacement through the GSRS mechanism, and then also through our our System Integrity Plan, or our SIP program. The commission is very involved in the review of those projects. There is quite a bit of a runway for us to continue to address those risky pipes in our system, but the commission is very involved in reviewing that and making sure that the projects that we are identifying and working on every year are truly addressing the risks in the system. So there's still quite a bit of work that needs to be done. And with these programs, though, it has absolutely accelerated, the progress that we have been making in the system on that.
Okay, very good. With those two questions as a bit of a backdrop, and I mean to be fair in the way I asked this, but the company has accepted a settlement that, by my calculation, is roughly 40% less than the ask. How can the company accomplish the goals that it had in mind for the original ask with a settlement that's 40% less than that?
Well, again, it was a compromise. I think the biggest issues or kind of drivers between where the company was at 19 million and where we ended up with the 12 was really around the cost of capital, which is about 3 million,
Yeah.
and then depreciation which was about another 4 million. I think we've come before the commission asking for increases, and have never truly gotten 100% of that. But, we are very diligent about planning for the dollars that we have received and making sure that we are continuing to invest in the system and modernizing our system so that we continue to provide that reliable service to our customers. So while it's not the full amount requested by the company, I can commit to you that we are making, good decisions on where that money is being spent so that it benefits all of our customers.
All right, fair enough. Let me turn the coin over a little bit and let me ask you from the company's perspective, how do you believe the customers benefit from the settlement agreement?
I think it's really just attributed to the reliable service that we've been able to continue to provide. I think one of the main concerns that we have heard from our customers is around affordability. And, affordability is a critical component of any of our investment plans and operations. We are also facing inflation pressures, just like many other industries are. But we have to incur costs because we are charged with the obligation to serve our customers. And it's in the public interest that we do that safely and reliably. And so I would just end with that we are absolutely providing the service that we are committed to providing.
Okay, very good. Thank you. Appreciate your indulgence on my questions. No further questions at this time.
Thank you. Commissioner Keither, any questions?
Good morning. Thank you for being here.
Good morning.
Just want to talk a little bit about the affordability because we're all getting pounded by consumers just out of their minds about the rates going up and going up and going up. And I understand your concern. Do you all have a program that helps consumers that have trouble paying?
We have a sharing the warrant program, yes, that we do direct customers who have called and need assistance. And we continue to partner with local agencies and leaders to provide access to our customers so that those that are needing assistance, we have that for them.
Okay, great. Thank you.
Mm-hmm.
Thank you.
All right. Good morning, Ms. O'Connor.
Good morning.
Just got a couple questions for you. I've read all your testimony. Appreciate that perspective. I don't think any of this will require you to reference testimony.
Okay.
One a bit more specific on capital structure, and to the extent you feel you can opine, it would be appreciated. I think I've asked this question before, and I may ask our staff when they get up again, but I was struck looking at some of the tables that Mr. Unrein put in his testimony, just the summary tables of the different capital structures that were proposed. I was struck that, well, one, you all have something similar to a 60-40 capital structure with 60% equity, correct?
That's correct.
Which not terribly surprising. I think we've seen that with other gas utilities. But I was struck at how low of a cost of debt you have compared to some other utilities that we have. And I guess I'd just ask you to opine for a minute on why you couldn't carry a higher level of debt, something closer to what our electric utilities have, which is closer to a 50-50, to take advantage of a lower cost of debt, which may be changing. But what's the overarching position and need to carry as much as 60% or more in equity?
Sure. Appreciate the question and an opportunity to explain a little more on this. It's the balance sheet that we carry at the company and supports the overall financial health. And so that in turn, allows us to access capital at a lower cost for our customers at lower rates. And so, the natural gas industry and Atmos, we have long-term obligations that we need to attain to. And so I think a great example of this would be during Winter Storm Uri and the company's response to be able to go out and access the capital markets because of our strong balance sheet, and was able to raise dollars to pay for the extreme and extraordinary gas costs during that time. And we were able to do it in a very short time period.
Has there been any discussion with the ratings agencies? Any indication that if you were to move somewhere closer to a 50-50 structure, that you would be in any danger of a ratings downgrade, or have you not had those conversations?
I personally have not been part of those conversations. Can absolutely get you some information on, touching base with our folks who do meet with those individuals.
Okay. I think we'll stop there on capital structure. We don't have to spend all morning on capital structure. The other thing I wanted to explore, it's actually just probably a different way of rephrasing the question Commissioner Keen had. I think he asked you why you're satisfied with the agreement. I want to ask a little differently. I know you've agreed to it. I know there's push and pull, and it all in all, you're asking us to approve it. Is there any component of the settlement agreement that gives the company particular heartburn, that you really had difficulty agreeing to, or that you don't feel is going to be supportive of good ongoing operations and growth in the future years?
Yeah, I think overall a return is probably the biggest thing for us. But I think where parties ended up and where we were able to agree to is satisfactory for the company, given in this case. Yeah.
Well, I appreciate that. I only ask it because, well, we obviously hear all the feedback on rates and concern about affordability, but believe it or not, we also get complaints that utilities may not be investing enough in their system to match growth in the area. So just that's the reason behind what I'm asking. So
Sure.
I don't have anything else for you. Commissioner Keen, Commissioner Keither.
Yeah, one follow-up, if I could, Mr. Connors. I understand from Mr. Flaherty's opening, which I thought was well done, Jim, as usual, that there was an impasse over several issues, including cloud computing, about which there could not be. What was the hang up there from your perspective? Why was that such a difficult hurdle to overcome?
I think it's just new. It's a new accounting treatment for a software that is being introduced. I think that you see the industry moving to more cloud-based, software. And so just really understanding how that was going to impact, I think, just the overall change. We, as Jim mentioned, we are asking for this type of treatment in, all of our jurisdictions that we operate in. And we've got approval in Texas, Mississippi, and Kentucky at this time. But, that uniform accounting treatment is very important to the company, because we would like to have that across the enterprise. And so I think just given the timing, if we're open to more conversations than I think other parties were, we were willing to give staff and CURB that additional time to talk through their concerns. And so we hope to bring that issue back.
Okay, so in terms of I'm overgeneralizing probably terribly, and I don't mean to be unfair. In terms of trying to be some uniformity in the treatment that the company is receiving from state to state. What was the Texas example that you raised? How was that distinguished?
Texas, so we're asking to capitalize those cloud computing costs versus them being an O&M expense.
Okay.
And so we are now capitalizing those costs associated with the cloud software.
Okay, got it. Thank you again.
Great. Yep.
All right, if we have no further questions from the commissioners, any need for redirect?
No redirect.
Okay. All right. Well, with that then, if there aren't any more questions, we do thank you for your testimony this morning, Ms. O'Connor, and you may step down.
Thank you.
All right. CURB, you may call your witness.
At this time, CURB calls Audrey Benham to the stand.
Good morning, Ms. Benham, and before you sit down, I'll have you raise your right hand for me. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth? All right, thank you. Please proceed.
Thank you, Mr. Chair. Good morning. Please tell us your name, occupation, including your business address.
My name is Audrey Benham, and my occupation is a regulatory accountant for the Citizens Utility Ratepayer Board, otherwise CURB. And my business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66661, or I'm sorry, 04.
Thank you. And I will note you're losing your voice a little bit. Okay, thank
do
you.
apologize.
Oh, thank you. And are you the same Audrey Benham that caused to be filed direct, cross-answering, and testimony in support of a unanimous settlement agreement on behalf of CURB in this docket?
Yes,
And do you have any changes or corrections to make to any of that testimony?
no.
At this time, I would tender the witness for commissioner questions. Thank you.
All right, thank you. And we will try to be quick and spare your voice. Are there any questions for this witness? Commissioner Keen?
Toward that end, I will really spare your voice. I have read through all of your pre-filed testimony. I think that suffices for me. I have no questions this morning.
Okay.
Commissioner Keither? Oh, I have one. I do apologize. I know that the customer charge, the fixed customer charge is always a big deal to CURB. And in this case, I believe your witness had proposed for it actually to go down from, I think the current is like $19.75, and your witness proposed for it to go down to $17.75. The settlement ends up moving it up to $23, but that is still lower than what I believe both staff and Atmos had proposed. So it could be seen as a win in some sense, but it's also going up in a material amount. And my understanding is the rationale is, that's about how much is already being collected on a fixed basis through the GSRS right now, plus a little more on top. So it's maybe not a huge impact. But I'm kind of curious from your perspective, if that's going to be the argument each time, is that we just roll the amount of GSRS in. I mean, it could have the impact of we're just going to increase it each time by, $5 or $6. From CURB's perspective, are you satisfied with the settlement? It's a one-off. You're going to fight that issue another day. Would it be helpful, or would it be helpful in the future or now for the commission to give some guidance on what a customer charge looks like? How much should it be as a percent of a typical bill? Is there some more guidance, or do you just feel comfortable on a one-off basis with what you've got here? I know that's a long, convoluted question.
To answer the latter question that you had, I think it would be helpful for the commission to kind of set or have some type of guidance on that issue. We did come up quite a bit, and I think that was partly through negotiations, where we were a little more favored on the revenue requirement and some of the other issues. For example, the abbreviated rate case was withdrawn. We initially opposed that. So I think there we were making some compromising and kind of leaning towards that higher customer charge in order to get a lower revenue requirement amount.
I appreciate that. I also appreciate that I did not ask you a black and white question, so that answer is perfectly appropriate. I believe that's the only thing I had for you. Any other questions from the other commissioners? Seeing none, no redirect necessary?
Correct. Thank you, Commissioner.
All right. With that, Ms. Benham, you may be dismissed. You may step down. We thank you for your testimony. And we will move directly to staff. You may call your witness.
Thank you, Chair. I would like to call staff's witness Chad Unrein to the stand, please.
All right, good morning, Mr. Unrein, and before you sit down, do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth? That was an I do for the record, if somebody's watching the recording later.
Good morning, Mr. Unrein. Please state your full name and title for the record.
My name is Chad Unrein. I'm hired by the commission staff as the Chief of Accounting and Financial Analysis here at the KCC.
And please state your business address.
It's 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
And are you the same Chad Unrein that caused to be filed in this docket testimony in support of the settlement agreement on January 16th, 2026?
Yes, I was.
And do you have any corrections or changes to make to that testimony at this time?
No, I do not.
And if I were to ask you the same questions here today, your answers would remain the same?
Yes.
Given the pre-filed testimony has already been entered into the record, I tender the witness for examination.
All right, thank you, Mr. Lateef. We will go directly to commissioner questions again. Commissioner Keen, any questions?
Yes, please. Good morning, Chad.
Good morning.
I'm going to ask you basically parallel questions to those I asked of the company witness. First question out of the box for me would be, why do you believe that the settlement agreement is beneficial to the company?
So, I mean, I think there's certain benefits from the company's side that staff, when we underwent analysis, makes sense in the docket. Both the GSRS and the system integrity plan are kind of additions outside of base rates that account for roughly 70% of their capital investment. It does not account for new investment, new pipeline put in the system, but from a system integrity standpoint and a GSR replacement standpoint, a good portion of the overall, capital addition growth that we've seen that is really a driver of the overall rate impact that we've seen from a customer perspective is being driven by these capital costs. And so while the overall investment wasn't quite, they didn't get the return, I guess, as much as what they otherwise filed for, I think there are certain beneficial aspects from the commission standpoint that helps investors get comfortable with the state's policy on ROE and overall cost of debt impacts.
Can you embellish that a bit?
Well, from a credit rating agency's standpoint, they're going to be looking at the overall support and staff policies that come out of the rate case. So they're definitely fully, integrated with the overall rate of return. However, I mean, there are additional policies and jurisdictions where certain rate case expense or overall rate costs are incorporated outside of the normal rate case mechanisms. And those are beneficial from an investor perspective because it allows for more frequent updates, and it's beneficial from a ratepayer perspective because there's not just an overall huge increase that sits out there that customers are not going to be paying for. And instead of a 25% rate increase, it's going to be more significant than that. And I think those mechanisms help give investors comfort as well as staff's general support from a Winter Storm Erie perspective. When they go to the capital markets and they have certainty of knowing those investor dollars are going to come back, it's a lot easier to get your cost of debt down. And so I think from that perspective, it's the totality of the commission policy that's really looked at in these rate cases, and the benefits that come out of the policy directives. I mean, we were at least able to get close to what our filed position was, And, you know, there were three particular policies from the abbreviated rate case, the tax tariff situation that, you know, got resolved via the settlement, and then the overall capitalization of cloud computing that was at least agreed to kind of allow for more discovery and commission policy perspective than what was put on the docket, I guess, for a decision in this docket.
Thank you very much for the granularity of that answer. I appreciate that very much. I think that's a good backdrop here. It strikes me that the staff, from its perspective, tried to go through several balancing propositions here in coming forward with its proposal and its final decision to agree to the settlement agreement.
Yeah, and I think I try to detail out the various impacts of how we got there. I mean, we moved from about 10.25 million to the 12 million, and a good portion of that was O&M spending. The overall O&M, they provided in rebuttal very, you know, formulaic responses that allowed staff to evaluate what were the cost increases that were driving O&M. And some of those are from a regulatory aspect of PHMSA and other regulatory initiatives that required additional spending in the rate year. And so when I did the analysis originally, it was more granular to looking at the overall cost increases for those accounts compared to the prior rate periods. But I do believe their witness testimony provided a good broad basis for the commission to understand the reasons O&M increases were incurred in the test period, and it gave staff comfort with the level of overall recommendation that got us to the 12 million net revenue requirement in the settlement agreement.
Very good. You actually answered the next question without me asking it, so the clairvoyance, I appreciate it. To the extent you haven't already answered it or you wish to embellish it a bit more, flip side, from the ratepayers' perspective, what benefits do you see accruing to ratepayers from the settlement agreement?
So, I mean, one of the things that from a ratepayer standpoint, a lot of the cost increases that we've seen are related to capital investments that are occurring, you know, within and between rate periods. And so from that aspect, the reliability, the building out of the infrastructure, you know, their ability to respond during cold ice storms to make sure reliability is retained, I mean, is paramount importance both to staff and I think from the company's perspective as well. And you know, while those investments continue to occur, it brings an additional drivers to the overall revenue requirement that are seen. The depreciation differences move particularly from what the company requested to mostly staff's revised position coming out of rebuttal. And so a lot of the capital investment drivers are what ratepayers are experiencing right now. And the overall just increases in the capital requirements that are from a debt perspective as well as a return on equity perspective.
Thanks again. I appreciate the granularity. Final question for you from me, Chad. Are you familiar with the rate case expenses in this particular docket?
Yes.
Can you just give us an overview of those and your take upon the reason, whether or not you believe they are reasonable under the circumstances?
So I did a review of the actual rate case expenses expended by both staff and Atmos. I mean, one of the things that I do find interesting is that, I mean, between Atmos's prior docket with the commission and its filed rate case expense in this case, we've seen an increase of about $5,000 between those rate cases. And so that's relatively 1%. You know, right now, the last rate case expense was around 716,000 and then 582 in this case. And I want to clarify that a lot of the cost difference is really on the curb and staff side. And that may have played into just when staff asked for those updates to occur and whether all of those expenses fully got recorded to the record at that time. So that I would expect that some of what the actual rate case expense that were experienced after staff's update may kind of help fill in the balance. But overall, the rate case expense, both you know, from a historical perspective, shows better variance, I guess, towards this particular case, and it's in line with other natural gas cases that staff has seen.
All right, thank you very much. Appreciate your indulgence on my questions. No further questions at this time.
All right, thank you. Commissioner Keith, are any questions?
No questions, but thank you for testifying and clarifying some things. Thank you.
Good morning, Mr. Unrein.
morning.
I'll just ask you some of the same questions I asked other parties. Just, I know you'll probably have a perspective on this, even though you're not the cost of capital witness, but I know we've had this discussion before about the gas utilities carrying a higher equity percentage, even though, you know, they may have a very low cost of debt potentially accessible to them. Can you just give me a little of staff's position on that? You obviously, in your proposed capital structure, staff went with that, didn't propose anything hypothetical, I don't think. So just staff position on appropriate capital structure and when you might you know, challenge a capital structure.
Yeah, in this particular case, I mean, staff looked at all of the known capital issuances. So there was a slight difference in the capital structure between the parties. Sometimes staff will look at hypothetical capital structures and the pre-tax RORs that would come out of it. In this particular case, you know, we've settled on the pre-tax ROR that, you know, staff witnesses kind of supported. The pre-tax ROR is actually identical to Kansas Gas Services pre-tax ROR. That's a carrying charge for their GSRS. You know, I would say the capital structure is a little bit lower than what was approved in the Kansas Gas case.
Lower as far as a smaller equity layer?
A smaller equity layer. I mean, it's several percents, but because these dollars, you know, within that portion of the overall case are a main driver of the overall case, we take particular, you know, we try to examine all the relevant issues that we can look at. We look at other states' return granted and try to analyze what risks the companies have outside of the approved mechanisms for additional investment growth. I think from a capital plan perspective, I mean, while a 55, 45 or 50 capital structure may be more beneficial, I think some of the differences between, you know, how much capital a natural gas entity may want to carry versus an electric entity wants to carry, it is specific to those utilities divisionally. And so and it's partly due to just the amount of capital expended and the amount of dollars that are going to be applied to the overall rate of return. On the gas side, the investment perspective, while I would say still maybe above historical use, it does provide significant benefits for both their cost of debt and the overall benefits from having an equity layer that's thick enough that if you got into a winter storm Uri type situation again, that they could go to the capital markets and access debt on behalf of ratepayers to help fund those type of unplanned expenses. And while we have made certain policy changes that has expanded the overall hedging program associated with those costs, the hedging programs in general would increase ratepayers' costs in years where those programs are not necessarily needed. But we've tried to lower the risk of that going forward, and we've tried to balance the interest between the overall rate of return, capital structure layer. And right now, we believe that at least, relative to the recent winter storms, the risks is still there, that there could be a storm the size of Uri, which it definitely helps having a thicker capital structure. And because they're only providing natural gas in comparison to electric, they don't have any additional coal or generation resources to rely on. They have to go straight to the market and pay what is market price for natural gas during those times.
Well, thank you for that answer. That's really comprehensive, really lays out pros and cons associated with the issue. So that's really helpful. I know this may not be the biggest issue that staff had in its case, but I do want to ask your opinion on the customer charge issue as well. I mean, I know we've got a settled customer charge that I believe is lower than what staff had proposed, but it's still a pretty material increase. As I said to Curb's witness, it looked like part of that was just justified by, a big chunk is already basically being recovered on a fixed basis through the GSRS. So, we could kind of get to this number. I have to apologize for not going back to staff's testimony and seeing what the basis was for your customer charge proposal. But does staff feel it would be helpful to have any sort of bigger guidance on, how much a customer charge can increase case to case? What % of a total bill should be a customer charge? Or is it most helpful for staff for that to be a lever available for negotiation in settlement discussions?
So, I mean, what policy recommendations are helpful, I guess, to see from a commission perspective of what, the overall customer charge should be, can help guide staff. I think one of the bigger things that needs to kind of be on the record related to this particular topic is that the class cost of service from a fixed and variable rate that is coming over and is analyzed from an Atmos versus what is actually charged, the fixed charge would be considerably higher than what staff's recommendations were in that case if we would just go straight to a fixed variable rate. And so while it may seem that just folding in the GSRS into the overall customer charge is reasons to support the overall increase, from staff's perspective, some of those underlying drivers of the fixed and variable costs, how much each class is actually adding to the fixed and variable costs, are really a prime driver for where our general settlement, purview is. It obviously would curbs request for a reduction in the customer charge, was, I think, helpful in getting a different perspective from a customer basis. And, the agreement was not to the level of what staff's recommendations were in the docket. We believe that the $23 customer charge is fully supported by the evidence in the record. And it does seem like most of the testimony, instead of focusing on that particular issue of fixed and variable rates and how much to pass on to retail customers, is driving that. A lot of the decision-making from staff's point of view is driven by those underlying elements in the overall customer charge that's passed on to customers.
Yeah, and I know, I thank you for refreshing me on staff's analytical position. I know in the past, I think it's been more applicants coming to us asking for a firm treatment of, maybe not straight fixed variable, but
Right.
Getting more into the fixed charges, because even staff's class cost of service analysis would show that. I could be wrong. I don't believe staff has ever asked for a firm methodology to be set. Is that your recollection?
No, I don't think there's been a firm commission policy perspective on this particular issue. And I don't know whether that guidance would, provide additional aid to settlement discussions, or would, be one lever that would not be available to be moved. So, staff tries to look at the overall totality of where those costs are when trying to come up with a settlement position. While Atmos quoted that, their original request was a residential bill impact of $9.12 a month, we ended up with 5.69% per month, with a 6.81% overall impact. But one of the things kind of hidden in that number is the fact that the GSRS from their position would have been retained outside of the overall rate that was permitted. And that was one of the beneficial impacts of having that issue settled going forward, because it provides just comparable numbers to kind of fully analyze where the overall rate request is, and it provides a kind of additional I think customer value or transparency in making sure staff and the company's positions are adequately explained on the record.
That's all very helpful. I think the only last line of questioning I have is just a continuation of some questioning you had with Commissioner Keene. And I think you were discussing, you know, some areas where this commission maybe has been historically less investor favorable, like a return on equity number. But I think you were talking about the balancing treatments and that the investor community, the ratings agencies are going to look at the full package. Would it be safe to say, if you're looking at the entire sort of regulatory atmosphere in Kansas as it pertains maybe to natural gas distribution companies, that we have been historically less favorable in setting a maximum allowed return. But if you look at the overall paradigm and mechanisms that we offer our utilities a pretty maybe a better chance at earning closer to their authorized return through the reduction of lag or through mechanisms that tell people ahead of time which types of costs they can expect to recover, so they have more certainty.
I think from our standpoint, from a Kansas standpoint, you know, the rate mechanisms available every time that we integrate a new one. We are very policy oriented and want to understand the scope and overall costs that we're looking at in giving you know, additional mechanisms to the utility that ratepayers are ultimately bearing. I think more from the investor community side, I think firm policy, you know, policy that allows for kind of a known and measurable, you know, focus on what to expect from a Kansas regulatory paradigm, I think is helpful. You know, it is that, I mean, staff has been, you know, a little bit lower on the recommended ROE range that, you know, other state jurisdictions may offer, but it definitely matters to the overall paradigm of, you know, how those other jurisdictions regulate rates. And I think, you know, providing customers with certainty on where those costs can be, the GSRS has a cap, spending cap, you know, the system integrity plan, while outside and available to Atmos, the other utilities did not require that from a natural gas standpoint. So that was one of the factors when we were evaluating abbreviated rate cases or changes to the overall O&M or overall increases for cloud computing from the capitalization standpoint that we looked at and tried to determine, you know, do we have enough on the record to support this? If it is a strategic long-term policy perspective that the commission would set, a lot of times we do like the commission guidance and to put that before the arguments. And I'm sure from a cloud computing standpoint, we will see that come in future rate cases. Right now, I would say that staff's open to consider maybe a policy directive in the long term. However, I mean, there are states that have pushed a cloud computing style arrangement, and in Illinois ended up, you know, the commission denying the overall request, and that was from like a 2020 decision, which is considerably later. But I think from the investor community perspective, I think they have a firm stance of where Kansas will and won't go and the support that ratepayers provide to the utility. And I think that guidance is of particular interest to investors because there's certainty.
Yeah. All right. Thank you, Mr. Unrein. Any follow-ups from my fellow commissioners? Seeing shaking of heads. So any need for redirect? I don't know who's.
No need for redirect.
All right, Mr. Unrein, we thank you for your testimony. You may step down. Just want to confirm with the parties. I don't have closing statements listed. Was there an agreement to forego closing statements? I'm assuming. Yes. Okay. All right. Any final concluding matters before I adjourn the hearing? All right, hearing none. This does conclude our hearing in docket number 26 ATMG 026 RTS. A commission order in this docket is due by March 24th. However, we do understand the parties have agreed and requested that the rates take effect March 1. So we will endeavor to issue an order before that time. If there are no further matters, we will adjourn. Thank you.